Shelby and the holdover, you wanted to, Bill Stratton had to leave. You wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a
117 miles per hour, then a 20-minute police chase. That's not just reckless, that's straight up felony territory. You've already got a second DWI, and now you add evading arrest. No wonder the judge calls him a red flag. Let me ask, you, if you were the judge, how would you handle someone this dangerous behind the wheel?
DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sure.
When he comes out.
Yes, sure.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able at that time to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated, second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison in the Texas in the TDCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
Hey, Judge. On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weave between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The IC was read and the defendant refused. A blood warrant was executed and blood was collected.
Can you run his license, please? See his license.
When a judge says, if you drive, I'll throw you in jail. That's not advice. That's a warning shot. So if he drives again, he's basically daring the court. The SCRAM device is no joke. It tracks every sip. This isn't just about punishment. It's about protection. But here's the debate. Is this tough love from the judge or just tough justice?
He doesn't know. So
At 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will invoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir. So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a SCRAM device within
Right.
3 days. Within 3 days of your release, you will be required to get a SCRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a SCRAM device.
It's a device that goes on your ankle so that we detect through perspiration whether you
Yeah,
are consuming.
drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign.
He tells the judge, I already served my time, but the judge fires back. A criminal record doesn't expire. Now he wants a plea deal, but the judge makes it crystal clear. This charge will stick. Jobs, housing, credit, it all gets harder. So here's the question. Is skipping a few days in jail really worth a permanent stain on your record?
This and then sign with Felicia and then.
Thank you, Judge.
All right. Thank you so much, Carl. I appreciate it. You sure you want to do this?
As we talked about probation, we talked about the
You
different
have no
choices they have.
convictions. You have no as far as I see, no convictions. Now, after today, you're going to end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
The choice is, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
I was lost when you was like 90 days at the.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future from now on, it's a minimum of 90 days if you take this deal, because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The
I'm
judge just
served
wants-
here, but what I'm saying is, you don't want to defer to try to keep it off. You just,
Sir, if you look at the computer, I've been in TDCJ before. It don't matter. It don't matter.
That's,
I'm just gonna
That's
be
like
honest
a-
with you. It don't
I
matter.
don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, and I
Okay.
at my time, I done did my lesson. So if time served, I don't have to go to jail. I don't have to look over my shoulder. That's fine with me. I walk a straight line. That just was unfortunate happened with my problem.
you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is going to go on your record. It'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the office?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
give me
Take
1
care.
second, get you this piece of paper, go downstairs so you don't have to go court cost.
All right.
I'll be with you.
I think the offense date was March the 30th, sir. So a little more.
No more.
Sir.
I'm going to test you 50 days from today.
Sure.
If I find that you continue to use, it's not going to go well for you. Do you understand?
Sure.
Do you have a job?
No, not at the moment.
It's time. It's time for you to start working and being productive. When you have too much time on your hands, you become self-destructive. That's what we don't want. I don't want you to pick up a 6th case or 7th case now within the next, that's it. I'm going to bring you back in 2.5 to 3 weeks and I want to see what you have done to get a job. If you've done nothing, you understand.
Yeah.
All right, good luck.
And he did let me know he has enrolled in HCC for the summer session of college.
That would be great. That's great. But if you're taking 6 hours, you got to do something else as well. If you're taking a full load, then great. The more schooling you do, the more money you're going to make in this life. Knowledge is power, and with knowledge, you get money. That's what this life is about, not convictions. Do you understand?
So,
Good luck. Thank you. Yes, ma'am. All right.
I apologize, Judge. I was in court 4 and just sitting there for a while until.
Don't worry about it. You're good. We're glad that you made it. Did Stradley come here today?
Yes, he already said it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second. It's a DWI second. We need to do conditions. And I know, but I still want to put conditions. He's going to bond out, I would imagine, right? But I'm putting conditions first. I want to get conditions so we get a guardian interlock and now. Yeah, see, yeah, I mean, I want to put conditions on, you know? And if you can't say that we can give him someone in the interest for now, just for purposes of conditions, okay? It's okay. Tom, here you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out.
All right.
Just let me know when you're ready, okay? Hi.
Thank you, Judge. I just wait here in the link.
Yes, ma'am. Good morning.
Good morning, Judge. I'm here on an off-docket matter. Is that okay?
Yes, okay, of course. What's your cost number?
There's two and Judge, hang on.
I forgot my eyeballs too.
There's a DWI and that's cause number 2556097. And there's a tampering.
This is on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the tampering. We didn't realize he had two.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted maybe the PR bond here. I got him from the jail. He went to immigration. April 2nd, posted a bond there. But we've got two warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a certain number of
What
days.
happens is that we don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued
a
a
warrant
warrant.
to tell you, Judge, so.
So he's made bond on the immigration case?
Yes.
Okay,
Yes.
so I can reinstate these bonds now,
Okay.
but as soon as he gets out, he needs to come here immediately for bond
Of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 255-6097. There's two. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so. Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's two.
Anthony Hernandez?
Yeah, please reinstate both.
Yes, sir.
Yeah. Tom,
I filed a dismissal in that case. I filed a dismissal.
Are you talking to me?
Yes, I filed a dismissal on when?
I appreciate it. Thank you, sir.
I'll sign it as soon as I get it too, okay?
Thank you, Judge.
All right.
Thank you,
take care.
counsel. Take care.
Reset, but I think the case is older than 150 days old.
Yeah, where we headed?
We're waiting on the RIP call and the 911 call. I believe the state has sent an escalated request.
Yeah, we've requested the 911 call twice, Your Honor. I'm not sure why it's not in yet. I would just request if we could just have one more sentence while I try and reach out and hound somebody to get the 911 in. It is.
Subpoena them to come to court. That's what I would do, you know, so give them 10 days, subpoena them to come to court. And then if they provide it to you, then great. If not, then, you know, but if they can't get you just the 911, then that's as simple as possible. Okay.
Yes, Your Honor.
So a 10-day discovery hearing. Yes, ma'am.
Thank you, Your Honor.
Sure.
Morning, Judge. My approach.
Yeah.
How you doing?
Hi, Mr. Ayala. How are you? What's new?
I've got Serato on your docket, copy for the, like you see.
Thanks. You too. What's new?
Is discovery complete?
She's got a bond violation. She failed to show up to a drug screen. She was at work. She did test yesterday and she tested negative.
Great.
Yes, sir.
Okay. Is she here now?
She is here.
Am I bringing her?
Yes, ma'am. Yes, sir.
Come up, ma'am.
And I'm gonna reach out to this man with the message.
Sure.
Oh, so we can go this up. I wanted to see if I would get some colors. Yeah,
I'm glad that you tested negative. Good job. Don't miss again, please. Okay, if it happens again, I'm gonna issue a warrant, okay? All right, good luck. Thank you. Thank you. Take care. Always. You said Miller?
Miller, Jeremy Miller.
Jail or bond?
On bond. Waived.
Say it again?
He's waived today, but on.
Okay. Threat, 156 days. It's an old
I know,
case.
Your Honor, we've been trying to get in touch with the complainant. But I'll read PC, Your Honor. On November 3rd, 2024, officers were dispatched to 15 over terrorist threat call. Upon arrival, officers met with the complainant, who advised she's employed at Benton Hospital as a registered nurse. Complainant advised that she was attempting to administer an IV needle in the arm of the defendant when the defendant stated, quote, "Bitch, take the needle out or I will kill you." Complainant said she took her life.
I mean, why?
So I would argue it's a conditional statement, Judge. It's take the needle out or this will happen. I think based on that, it's not an imminent threat, but it's a conditional. If you do this, I will do this. So I don't think it meets the statute for probable cause.
I mean, Your Honor, I would argue that, threatening to kill her in a hospital.
I mean, can that possibly be the law? So anybody can ever, if there's a condition, then it's never a terrorist threat,
I would need to look at the case law.
that would be,
I know there's someone with agreements.
let me pull up the statute. Hold on, let's see.
But I know that the way it's charged, Your Honor, is imminent serious bodily or death.
Person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to cause a reaction of any type to his threat, place any person in fear of imminent serious bodily injury. I mean, it doesn't say if it's conditioned that, because the statement is he's saying, I'm gonna what?
I said, quote, "Bitch, take the needle out or I'll kill you."
I mean, show me some kind of case law that says that a condition fills it, and then I'm with you. But I mean, there's obviously it's a threat,
I can look at
and the needle's in his arm at the time, right?
Correct.
Yeah, I mean, if you show me that a conditional statement it's no good, then I'm with you.
And then I also wanted to ask you about Todd Wallace. That's
I remember
Judge
Mr. Wallace. How's he doing?
So, Judge, I've not been able to have contact with him. I went by yesterday in person, trying to reach him, and just have not been
You
able to
said
reach him.
it today because you couldn't get in contact with him, right?
Correct.
Okay. So I guess I'll revoke it.
And I spoke with Chief. He's essentially leaving the offer on the table of just an apology letter and a dismissal if he does end up back in custody. So
I'll
he
leave
made a note of that.
I'll leave the first setting to Your Honor if he does come back.
Did you put that in the notes?
I already put a note in there,
I
Your
put a
Honor.
specific note for
I'm going to
us.
revoke it now just because you have no contact. If he should show up, then we'll talk.
The exact note I have, Your Honor, is proposed defendant is going to bond forfeit. When he comes back into custody, I will keep the apology letter offer open for 1
Yeah,
second.
we just don't know what circumstances are going on.
Yeah, I understand.
So, I'll do 1501. Or, sorry, 2501. Hey, so 2501 on Wallace. And I'm not going to do a BO.